6SM, Appearances Counsel.
Carnes on behalf of the people.
Thank you, Your Honor. Taylor Ann Anford Bentel on behalf of Mr. Waters, who joins me at council table.
All right, and I know we're set for the final pretrial, and we currently have a trial set for May 1st. Is there any resolution to this matter at all?
There is not, Your Honor. The people did extend an offer of disturbing the peace. I reviewed that with my client. My client is choosing to reject that offer, and he would like to move forward to trial. It's my understanding we're going to set for May 1st.
Correct. Mr. Waters is currently sitting with a remand because his bond was revoked yesterday due to his second violation. So it looks like this will be in first position for May 1st. Are the parties ready for trial?
Yes, Your Honor.
I can be ready for this one, Your Honor.
All right. Then we will notice, just so everyone's aware, notices have gone out to the jury. However, when they first went out, the computer populated the wrong date. So new notices have been sent, just so everybody's aware of that. So we should be all right.
Your Honor,
Yes.
thank you. My client was asking about addressing bond. I was standing up.
All right.
If I may make a motion for bond, Your Honor.
Any objection, Mr. Carnes?
No objection to hearing it, Your Honor.
All right. Ms. Fioravento?
Thank you, Your Honor. My client would respectfully request that he be allowed out on bond and he'd be willing to consent to whatever other terms the court thinks is necessary. At this point, he has sat a substantial number of days. It's my understanding contact has been a concern. Again, he is willing to have a GPS tether, whatever other options the court thinks is necessary. I would also say that it's my understanding the complaint in this file wants the no contest dropped. She has been contacting the prosecutor's office, and my understanding contacting our office. In light of all of that, Your Honor, it's my understanding there's still some child custody, guardianship, CPS issue going on. These parties want to address that. As a joint unit with CPS?
I was told yesterday that the CPS case was, at least they had the child back. So is there still a CPS case going?
My client reports that the child was returned and then the child was then returned back to the child's uncle for caring for the child because my client's significant other, the complainant here, is not capable of caring for a child without assistance. She really needs that help.
But is there still a CPS case open? First of all, I guess,
yes.
Was there ever a case open?
So I am not exactly sure of the situation. There was some level of CPS involvement. We did have a witness from CPS here. From what my client has described to me, it sounds like it was some sort of guardianship instead of an abuse and neglect proceeding, and that they were trying to get a guardianship overturned and have a child returned, which is still involves CPS, but would be a different procedural avenue. That's from what my client has described to me about the case. I have not looked up the specifics. Also considering that we had a removed child but no court-appointed attorney, that would also make me think that that was some sort of guardianship proceeding, which CPS again would be involved in, but not to the same extent you would see with an abuse and neglect proceeding.
Okay.
I would also emphasize though that this complaint between the time that the original officers responded to the alleged complaint and the time this file was first brought, there was a significant period of time, I think it was about a month, where there were no further alleged incidents. And we have not had any further alleged incidents of domestic violence throughout this. All the issues with bond have been related to that no contact. We're making no excuses there. My client has previously pled to those. But we would just respectfully request that Your Honor allow him another chance at a personal cognizance bond between now and the time of trial. It will make any further preparations that may or may not need to be done easier. It will make it easier for him to obtain appropriate clothing for the trial. And again, we have not had further violent acts. We have not had drinking issues. We have not had issues with other neighbors. We haven't had any of these public safety concerns. And in light of all that, Your Honor, we would just respectfully request another chance at a PR and for the no contact to be lifted, or at least some sort of limited no contact, so the parties can continue to hearing this trial. Thank you.
Mr. Carnes?
Thank you, Your Honor. What we've had throughout the pendency of this case is a flagrant disregard for the court's no contact order. Going back to the time period, so we had a bond violation hearing on March 25th. After that hearing, I got a copy of a text message, which is attached to the most recent petition that I think is more disturbing than anything addressed at that March 25th hearing. On March 19th, there was a text message where the defendant texted the victim to ask if she was going to help at court. That comes as close to witness tampering as I can see. And then in the most recent violation, he's also violating a trespass request from the apartment complex's property manager who had trespassed at the beginning of this case. So he's breaking the court's no contact order. He's breaking he's committing a misdemeanor trespass.
Is there another violation? I just have 2 no contacts. Is there?
We focused on the no contact component of that. And I've been very busy, so I didn't even bother to throw in the new criminal conduct of trespass. But in order to have contact with her where he did, he had to violate, he had to enter a property he had been trespassed from, which is the victim's apartment complex.
Okay, I just want to make sure I wasn't missing one.
It's not a new incident.
Okay.
Anyway, I think a remand is appropriate given the repeated violations of the no contact order, which seem to have been going on throughout the entire pendency of this case.
Any rebuttal?
Thank you, Your Honor. Again, nothing violent. There's no excuse, and we're not making any excuses. But Your Honor, we would just respectfully request that personal cognizance bond. Again, we would ask the court to incline is going to consent to whatever terms and conditions the court thinks is necessary to ensure there is compliance going forward, and be that tether, be that whatever the court thinks is needed.
Thank you. You mentioned jail, the time that he spent in jail. Do you know how many days he has? We show he's got 15, so I just wanted to make sure that we're on the same page.
Trying to see when he was, because he was picked up.
So we show March 19th to April 1st, that'd be 13 days. And then 21st of this month through today would be the.
I'll defer to the court there. Thank you,
Okay.
Your Honor.
All right. All right. Mr. Waters was originally arraigned back on January 21st. He was given a personal recognizance bond with the conditions that the standard conditions, and that he not have any contact with the alleged victim in this case. Then there was a bond violation hearing on the 25th of March, in which bond was modified based on a no contact order violation. Admittedly, he did plead to that violation, but the court then modified bond to a $10,000 cash surety bond. It looks like there was also a fail to appear back on January 15th. But that may have been taken care of. It's somebody else's writing, so let me see if I can find that in the file. Looks like that was for a fail to appear at the arraignment. He was arraigned on the 21st, so it looks like that was taken care of. And then yesterday, he pled guilty to the bond violation, again, for violating the no contact order. The court imposed bond at that time. The allegations and I shouldn't say the allegations. Mr. Waters explained to the court yesterday that there was violation of the no contact orders because the child had been returned and the mother could not care for the child. And so he was trying with the necessary needs. And so he was trying to get those necessary things that were needed so she could then take care of the child. But what was pressing on the court once I did some more questioning of the defendant was that by that time, or at least at some point, the child had been, I don't want to say given back, but had been given into the care and custody of other family members who were able to take care of it. So the pressing issues that required the violation of the no contact orders were less pressing because the child was being taken care of.
I wouldn't say she's being taken care of, but rather.
Mr. Waters, it's going to be in your best interest to talk through your attorney. Okay, so if there's something you want her to know, to express to me, go ahead and talk to her about that. Mr. Bento, do you wish to?
So the concern is, Your Honor, he does not want his child in the care of this other person. And he feels the only reason the child ended up in the care of the other person is because the child's mother needs assistance to care for the child. He wants that assistance to come from him as the child's father instead of someone else. And the only thing really stopping that reunification of a family unit is that no contact.
And I understand that. I understand based on what I heard yesterday that was the concern. However, it's at least at the time that, at least towards the end of the no contact violations, the child was not with its mother. And so it's not like it was living out in the elements, starving and not being taken care of. The level of being taken care of, etc., everybody, parents different, has their own philosophies. I understand that. But as far as the immediate need to violate the no contact orders, I did not believe it rose to the level of having to violate those no contact orders. So that is why the bond was revoked. We've had 2 violations of the no contact orders.
Your Honor, if I can speak on it.
And so Mr. Waters.
We are both scared of our daughter being manipulated and taken away from us.
I understand.
We're not worried about.
Okay, Mr. Waters, it's my turn.
We're worried about
okay.
her being mistreated. All right, come on. You're helping my daughter being
Do not go away from me.
neglected and taken away.
Get out. Go away from me one more time.
You're helping my daughter be neglected and taken away. Get out. Pull away from me one more time.
And he'll be by Zoom. Okay. All right, thank you.
What started as a routine bond hearing turned into a powerful reminder of how quickly emotions can derail a case. No matter the intention, whether it's about family, frustration, or fear, violating court orders only makes things worse in the eyes of the law. The judge made it clear, rules in the courtroom aren't optional, even when personal stakes feel overwhelming. In the end, this wasn't just about custody or contact, it was about accountability. But here's the real question. When emotions take over like this, should the court show more understanding, or double down on discipline?